Hello, everyone. As always, we're very happy to be here today in this session of our seminar series, Topics in Early Modern Studies, and we deeply appreciate your participation. Before I introduce today's speaker, I'd like to give you the house rules. Please keep your microphones muted during the entire talk. We will have time for questions after the presentation. I would also ask you to either write your questions in the chat or use the raise your hand function to let us know that you'd like to speak, whichever you feel most comfortable with. When writing in the chat, please feel free to make your questions in either English, Portuguese, Spanish, or French. Finally, I would also like to remind you that this session is being recorded and will be available on our YouTube channel later in the next semester. It was with great pleasure today that we welcome Professor Michael Braddick. Professor Braddick obtained his BA and his PhD degrees at the Cambridge University. He was a visiting assistant professor at the University of Alabama and assistant professor at Birmingham Southern College in Alabama, before joining the University of Sheffield in 1990 as a professor of history. He has been awarded various fellowships, including the British Academy and the Lilburn Trust, as well as numerous visiting scholarships at the Huntington Library in California, the Institute for Advanced Study in Princeton, and the École des Hautes Études en Sciences Sociales in Paris, along many others. His research interests encompass the early modern state formation, the English Revolution, John Lilburn and the Levellers, and political agency in early modern England, Ireland, and the British Atlantic, to cite but a few. He is the author of 5 books, which include The Common Freedom of the People, John Lilburn and the English Revolution, as well as God's Fury, England's Fire, A New History of the English Civil Wars, as well as various papers and chapters, and he has also worked as editor and co-editor of essay collections and special editions such as Suffering and Happiness in England, Narratives and Representation. His presentation today is titled Against Anti-Formalism, John Lilburn, the Levellers, and Legal Agency. Thank you very much for accepting our invitation, Professor, and the floor is yours.
Thank you very much. I want to give a couple of comments by way of explanation for the provenance of this paper because it explains a little bit of its shape. It's a response to a commission asking for reflections about the Levellers and English Civil War radicals and what they might have to say to current political debates. And I say that because that's the kind of engagement with the 1640s that has been out of fashion for many years, and some people may simply not like that approach. But I'm not, I hope, being simply teleological. I'm trying to extract another strand of meaning from how the Levellers viewed themselves and suggesting that that strand of meaning has some resonance in contemporary debate. What I'm arguing against is a view that the Levellers were primarily motivated by their religious faith, that if you want to explain the coherence and meaning of their movement, you need to understand their practical Christianity, and that their interest in forms was simply tactical. Constitutional legal change was for them a means to a much deeper end. And what I want to recover is the importance to John Lilburn in particular of legal agency, alongside, of course, his practical Christianity. But the legal agency was not simply incidental to his Christian faith, it was quite central to his political campaigns. I then go on to argue that that's true of other Levellers too. And then I reflect on what we might learn for contemporary politics from this attention to the Levellers' interest in legal agency. And the term used to discount all this is formalism. This is the very influential and important work of Colin Davis, J.C. Davis, arguing that a very important and radical strand of 1640s political thinking was anti-formalism, a suspicion of any human forms which stood in the way of realizing God's will for the world, to summarize a little crudely. So my paper is against anti-formalism because I want to recover the radical potential of formalist political thought through John Lilburn, the Levellers and legal agency. So could I have the first slide? Oh no. So the view that an interest in forms was a dilution of radicalism has deep roots. There's a strand of this in Christopher Hill's writing, a distinction that was important to Christopher Hill between the Levellers and the true Levellers, the diggers, the people who overthrew all the structures of human society seeking to establish social life on a new basis without regard to received forms. And that was the distinction between Levellers like John Lilburn, attached to their legal rights and inherited rights, and the true radicals, the true Levellers, people interested in refounding society on new principles, on a new law of righteousness, specifically in Gerald Winstanley's case. But that has a deeper root than Christopher Hill. William Goodwin, the Romantic historian, said of John Lilburn that he was a slave of the rules of privilege and law, which are adapted for ordinary times. The implication being that for extraordinary times, you needed a more anti-formalist radicalism. And Thomas Carlyle referred to John Lilburn as a contentious, disloyal, commonplace man, little distinguished save by his ill nature, his blindness to superior worth, and the dark internal fermentation of his own poor, angry, limited mind. So these views of Lilburn stand in contrast to the real visionaries, the people who were willing to start society afresh. And there's a strong tradition in these and other writers of seeing a commitment to preserving forms from the past as a kind of shying away from the real potential for radical change that others were identifying at this time. And so I'm arguing against that and trying to recover the value of a radical formalism. And a key issue in my approach to the forum to which this paper is ultimately going to contribute is to distinguish between a commitment to popular sovereignty and a commitment to populism. The institutions and norms of the Constitution are presented by populists as potential restraints on the majority will, impediments to democracy, or even the enemies of the people. In the UK, we had a lot of this kind of talk around the Brexit debate, the binding nature of a referendum, how judges could not intervene in constitutional matters against the will of the people, and so forth. Two authors who've informed my thinking about how to grapple with this, because I believe both in popular sovereignty, but also that populism needs restraint, are Richard Tuck, the Sleeping Sovereign, who argues that the authorization of what the people authorize is the basis of government. They do not necessarily participate in deliberation and legislation. The people are a sleeping sovereign. They authorize the government to act, but they do not intervene on every decision the government then takes. And Daniel Lee makes a similar distinction between constitutions and government, that the early modern view of popular sovereignty was that popular sovereignty licensed the constitution, but didn't direct the government, and that a constitution that was popular in origin could take more or less any form thereafter, as long as ultimately the power of government rested on the consent of the people in some way. So an important way of thinking about the distinction between populism and sovereignty is to lay value on forms and to see those forms as matters of government rather than constitution. And to put that in the terms that Tuck and Lee have laid out, is to say that you can distinguish between popular sovereignty in the constitution and majoritarianism in deliberation and legislation. In effect, the forum I'm dealing with, engaging with, is dealing with unease about the extent to which a commitment to forms can subsist with a commitment to the sovereignty of the popular will. And in that context, I'm revisiting the levelist views of the relationship between popular sovereignty, personal liberty, and legal forms, primarily through John Lilburn as the most formalistic of the levellers, referred to by some of his fellow travellers as John Lawmind. I think there's something worth recovering and pondering in Lilburn's commitment to the common law and legal agency as the basis of individual and collective freedom. This is far more prominent in his writing, in fact, than majoritarianism, and it takes us further than a concentration on representation and franchise reform in understanding what the levellers were trying to achieve. It's radical in these ways, although it falls far short of the anti-formalism of people like Winstanley. So a key claim is that in terms of the categories laid out here, the franchise debate around which much discussion of the levellers hinges, that in terms of the categories laid out in the franchise debate, that is about sovereignty, not deliberation, and that practical freedom for the levellers lay in majoritarian rules, not in majoritarian rules in deliberation and legislation, but guarantees of legal agency and legal freedoms. So that's the agenda for the paper. It's unfashionable to do this for a number of reasons, some of which I've also already set out, but one of them is that it's unfashionable to talk about the levellers as legal rather than Christian thinkers. This is partly a consequence of the literature spawned by Colin Davis, and I'll return to this below, but the key thing is this interest in legal agency incidental to their thought, a matter of forms for people who were really ultimately anti-formalist? These were simply a means to a much more radical, profound transformation of society derived from their Christian principles. He argues that the levellers make no real distinction between the realms of nature and of grace, the world in which we live and the world of the divine creation, and that their concerns reflect practical Christianity, particularly the example of what they mean by fairness, the golden mean, so that their views of Christian fairness in the realm of grace are directly applicable to the realm of nature without any intermediation at all. They make no distinction between the realm of nature and grace. And their pragmatism in the realm of nature follows from this. Forms always remain secondary to them, says Colin. The agreements of the people are tactical documents designed to secure a practical alliance with the army. His major preoccupation was to recover the fundamental place of traditional Christian stewardship in their thinking. Now, all that is important work, and I'm not at all here to say that Christianity is not important to the levellers. One key concern of Collins was to see the levellers in their own terms and not as modern socialists or modern democrats, and his purpose in emphasising their Christianity was to go against the teleology which saw in the levellers the origins of ourselves. But I think in doing that, he has dropped an interest in things that the levellers would have recognised as important to their own thought, and that is legal agency. So I'm trying to, again, steer a middle way here between seeing the levellers in terms that they wouldn't have understood, a teleology, and seeing them as only Christian thinkers. I think you can see them as Christian and legal thinkers in terms they would have understood and draw meaning for our contemporary debate from the legal strand of their thought. So the next slide, please. Firstly, I'm going to talk quickly about Lilburn and legal agency. I'll try to get through this a bit more quickly from now on. So there's John Lilburn in court holding Cook's Institutes, dressed as a 17th century gentleman asserting his masculine authority. It's one of the most famous images of Lilburn, and it's really this image that was concretely and consciously constructed with Lilburn's help that I want to understand. And I want to suggest that this image of the honourable gentleman vindicating his rights in an open court of law is as important to him as the image of the Christian martyr, which he was equally keen to promote. Lilburn said of himself in 1649 that his career had seen 4 contests with the bishops, then the House of Lords and Commons together, and then the Council of State. Only one of these contests is explicitly about the nature of the true religion. And what he said about all four of them was, in all the books and papers he'd published in these battles, he constantly and fearlessly opposed himself against the tyranny of the times, not in the least in opposition to a just government, having always, as now, had the law of England on my side. He saw these four contests as battles against tyranny, in which he had law on his side. It's intrinsic to his view of his own public career. Equally important to his view of his own public career was the value of having his day in court, a day to vindicate his rights and to submit them to open and fair adjudication. Some of this has roots in the Protestant tradition of disputation. So in his early contest with the bishops, he said, "I've challenged a dispute with them for my life before the king to prove their calling," the bishops, "to prove their calling to be from the devil. And if I were erroneous, and if they by God's word could confute me, I would recant publicly." So this assertion of a desire for public arbitration and a day in court and so on does have roots in that Protestant tradition of disputation. But it also has its roots in an attachment to the due process of the English common law. He said in his pillory, in the course of that same dispute in the pillory, "If I be an offender, I desire the extremity of the law may be inflicted on me to the utmost. In all this, I am my sovereign's faithful and liege subject, yea, one as faithful to his crown as any whatsoever that breathes in all his dominions. For if it can ever be proved that I ever broke any of his laws, I will submit unto and suffer whatsoever authority will lay upon me." Failure to allow him his legal rights to that hearing, though, represented what he called club law. He thought the government was exercising force against him, and that he should be allowed his vindication of his view under due process. If he lost that vindication, then he submitted to the findings of the court. This is an important element of English gentry culture, of course, in the 16th and 17th century. And there was more than a suggestion of martial language in his self-assertion. "I already made 3 challenges to dispute with you, but you are so cowardly that you dare not come into the plain and open field, but you fight with tyrant-like weapons, namely with cruelty. And therefore, to see whether you have any manhood in you or no, I make and send forth this 4th challenge for an open disputation." In 1643, he was captured by the royalists in battle and put on trial for treason. His first notable act in that trial was to refuse to plead when described as the son of a yeoman, for that he'd admit nothing on record so much to the prejudice of my family. And later in the trial, asked by Prince Rupert how he would like to die, he demanded a sword, telling them he decided to die in single opposition, man to man, with any there, or if they feared the trial, 2, so that he might die with honour. And there are many other stories of Lilburn's honourable display, refusing to take his hat off, refusing to kneel at the bar of the House of Lords, and so forth. He was acutely conscious of status distinctions and played them politically to great effect throughout his career. And a part of this, finally, is family honour. I'll abbreviate this section altogether, but his father, Richard Lilburn, was involved in a property dispute over the Lilburn family property in the northeast. In the course of a dispute lasting 5 generations, crucial legal documents had been lost. When the dispute was revived in the 1630s, Richard Lilburn felt he couldn't defend himself using documents which he claimed had been lost and seizures earlier in previous generations. His solution was to claim a right to trial by battle, and he turned up at Durham Assizes with a champion and with rules of engagement which survive in the British Library for a battle unto death to decide this legal dispute. And I think that vindication of family legal rights through open arbitration by agreed rules, which will result in a finding, we can see the imprint of that throughout Lilburn's public career. He felt that in order to vindicate his views, he would have his day in court, and he would demand due process, and he would abide by the outcome. I think this makes sense also of his post-leveler career, where he went into a career in advocacy. He tried to get admission to the Inns of Court to become a lawyer, and he represented people in court, including his own uncle, but also a number of others, including commoners in the Isle, in the Fens in Lincolnshire. And in all that, he was vindicating what he said the Commonwealth was. The Commonwealth, after 1649, he said, was the good and true laws of England and the good and lawful people. It was not the regime of that name. And so he continued after 1649 to fight for the good and lawful rights of the good and lawful people of England through a career in advocacy. And he also did it in dispute with one of his own tenants, William Huntingdon. Lilburn was given lands in compensation for sufferings during the war, and with those lands he inherited this tenant, William Huntingdon, who Lilburn claimed had wanted the lands for himself and had become a very difficult tenant. Lilburn crushed Huntingdon, asserting his rights in a particularly brutal way, so that Huntingdon turned up at the House of Commons saying he'd walked barefoot from the northeast, and that Lilburn had left him but a poor sickly woman and 5 small children and not a cow's milk to stay their hungry hearts. While allowing for the performative element of this, Lilburn's treatment of Huntingdon has been seen as hypocritical. If we see Lilburn as a proto-socialist, this looks just straightforwardly hypocritical. But if we see him as someone committed to family honour, gentry honour, legal rights, legal forms, his right to vindicate his landlord's rights over Huntingdon seems entirely consistent with the way that Lilburn carried on before. I'm not saying it's attractive, but I'm saying it's consistent with this emphasis on legal agency, knowing your own rights and being able to vindicate them through due process in an open court. So I think all that legal agency is clearly very important to Lilburn. And I think it is distinct from his view of the church because these legal rights are specifically English. They are the product of English history and English institutions. They belong to the English and not to the Scots or the Irish. He's credited with the term freeborn Englishman. So it's a civic law belonging to the English. And he believed that denizens could access these rights. You didn't have to be born English, but you could become a citizen and enjoy the benefits of these rights that are specifically English civic law. And that's distinct from the church, which he says was not a national institution. Christ had left his authority in the body of particular, not national churches. So to import Christian principles into the civic law is in some sense a category error here, because it's to apply to a national community something which doesn't belong to a national community. The civic law belongs to a national community. Christ left his authority in particular, not national churches. Further evidence of his view that these secular rights are distinctively civic and national. In 1652, where he was in Holland when war broke out between England and Holland, and he argued there for the freedom of nations, getting him the title of traitor in England, saying that the Dutch affairs were for the Dutch and not for the English. And it's striking in that context, I think, that Lilburn, as far as I can see, didn't say much, if anything, about the Irish or the Scots. That was a matter for them, and his concern about rights was not restricted to the English system, the English civic system, and to those who benefited from it. So that's Lilburn and legal agency and the constitutional nature of legal rights for Lilburn. If I have the next slide. How true is this of the levellers more generally? Well, on the 150th page is a fragment, is a broadside published by Lilburn, acknowledged to be Lilburn's, and it became the first section of one of the early leveller pamphlets, England's Birthright, where a list of more specific grievances is added. England's Birthright appeared alongside England's Lamentable Slavery, and these two pamphlets, the Birthright and the Lamentable Slavery, are seen as the coalescence of a level of movement. So it's these two texts are quite important for the moment of cementing of this alliance. But the 150th page is actually a series of 6 or 7, I think, complaints about specific things, specific legal abuses by the current regime which need remedy. And the 150th page in England's Birthright Justified, which expands on that with further examples of specific legal malpractices, cast the levellers as people who want to restrain executive power over the individual. England's Lamentable Slavery, on the other hand, does conform much more closely to Colin Davis's view of the levellers as people interested in Christian renewal, the refounding of society based on a Christian egalitarianism, and a desire to sweep away corruptions and a willingness to throw away the detritus from the past in order to establish the new society. So what are we to make of this confluence of Lilburn's rather particular formalist legal complaints with the Lamentable Slavery's commitment to much more fundamental, apparently much more philosophical forms of radicalism? Well, from this point of view, and this is something I argued in my book, we might see the Leveller campaign as a coalition to secure an agreement of the people as a solution to the current impasse. And it's a coalition of people interested in that as a solution to the current problem. What they're reacting to is either a deal with the king or a Presbyterian settlement. And as an alternative to either of those two settlements, they propose a third. And that third settlement, the agreement of the people, is, I would argue, intended really to restrain executive power over the individual. It's not to establish the majoritarian principle. The agreement of the people is intended to allow for the removal of corrupt or ineffective representatives and protect the individual by means of reserved powers, things that the legislature can never legislate against. It was not primarily or even very visibly a campaign for the majoritarian principle in matters of deliberation and legislation. It was a campaign to make it possible to remove the executive when it abused its position. The bulwark against tyranny was partly regular elections based on a broad franchise, but it was also the formal legal rights which appear in the 150th page in England's Birthright Justified. In this context, formalism was a restraint on the executive, not on the citizen. It was a means of vindicating the rights of the citizen against the executive. The citizen was empowered partly by the capacity to remove the executive, but they were also empowered through law and the courts. So in this context, we might see the agreement less in a democratic context and more in the context of the rights tradition. As they say, having by woeful experience found the prevalence of corrupt interests powerfully inclining most men once entrusted with authority to pervert the same to their own domination and to the prejudice of our peace and liberties, we therefore agree and declare. It seems very clear that the purpose there is to prevent the corruption of power in the executive and to offer the citizen means to restrain the tyranny of the executive, one means of which is annual elections, but other means are the forms of legal agency that were so dear to Lilburn. Now, in making that case, I have to deal with the uncomfortable fact that Wallen and Overton don't seem to think this, but Lilburn does. And that argument is put most clearly in relation to the Magna Carta and the Norman yoke. Again, trying to abbreviate what I've got here, but Magna Carta is seen as something that could be seen as something that recovered rights that had been lost at the Norman conquest, or it could be something that established new rights extracted from an unwilling crown. On the one hand, then, there are fundamental rights which precede the establishment of the Norman monarchy and are fundamental. Or on the other hand, Magna Carta is something that was just a deal. It's an imperfect deal. It was the best they could get in 1215, and really we need a better deal now. And this is the distinction between Lilburn and Cook, who saw Magna Carta as something that preceded the monarchy and declared rights that existed prior to the monarchy, and Wallen and Overton, who seem to have thought much more that rights were something you had to extract from the monarchy, and that now was the moment to extract them properly. So that might suggest then that my argument fails, because the Levellers clearly think very different things about the law. But I think two things about that. One is it depends which bit of which Leveller pamphlet you read, and secondly, it depends on which Levellers you listen to. So Baldwin, if we follow Christopher Brooks' account, could see the practical value of legal forms in restraining a tyrannous parliament, and goaded by William Prynne, he went into a denunciation of the corruption of the legal profession, claiming that it prevented access to valuable legal forms and legal rights, exactly in the way that Lilburn might have argued. So on. You could trade quotes about this, but Wallen and Overton are less consistent than is sometimes claimed in discounting the value of Magna Carta. But then there are other Levellers like John Streeter and John Waugh, who, like Lilburn, see legal forms as absolutely central to the Englishman's freedoms. So John Streeter published a series of pamphlets during the 1650s concerning practical freedoms, recognising that law without consent was no law, and therefore recognising the importance of parliamentary reform. He nonetheless concentrated on practical legal agency. Law should be available in English, it should be cheap, the process should be quick, the process should be understandable by the people enjoying the protections of the law, and so forth. And John Waugh published extensively on the corruption and deficiency of the laws of England, arguing that the measure of just laws was threefold: their origin, how they were administered, and their use or end. English law as currently practiced failed on all three grounds, he said. It arose from conquest, taking the kind of anti-Lilburn line. But he also placed great emphasis on the fact that its administration was shaped by corrupt will and principles of unrighteousness, and its use and effect was the grievance, trouble, and bondage of the people when it should have been their liberation. So in these contexts, Lilburn, Streeter, and Waugh, but also on some occasions Wallen and Overton, are arguing that the common freedom is constituted and instantiated in legal agency, equality before the law, and equal access to its protections and privileges. As we've seen, Lilburn was as interested in rights to open trial, freedom from self-incrimination, and the independence of juries as he was to the freedom of parliaments. So all this leads me to think, should we be thinking of the Levellers as united by the virtues of an agreement of the people as a solution to the immediate problem, rather than a group united at some fundamental ideological level who saw the agreement of the people as an alliance with the army as a means to that fundamental ideological end? In other words, is this a coalition, a mobilisation over 3 or 4 years in the late 1640s for a particular kind of peace settlement, rather than an instrumental document designed to implement something which we could define coherently as Leveller thought? And here is my annoying question, is whether Leveller thought is not perhaps an unexplored category. Did these people really actually all think the same at all? And secondly, following on from that, in a slightly fuller engagement with Colin Davis, is Leveller religion perhaps prey to the same problem? The Levellers are people united by support for an agreement of the people, perhaps, rather than support for a fundamental ideological position or a particular religious position. So to Colin Davis, Christian morality gave them their one element of formal consistency in the face of all these diverse views of legal matters. What's consistent is their Christianity, but I wonder if that's really true. William Wallen, very early on, says to Lilburn, although there's some difference between you and me in matters of religion, yet that hath no whit abated in me the great love and respect justly due unto you for your constant zealous affection to the Commonwealth, and for your undaunted resolution in defence of the common freedom of the people. So Wallen himself thinks it's not religion that binds them together, it's a desire to defend the common freedom of the people. And the agreement of the people does that by defending the citizen from tyranny. And you might go further and say, if you wanted to prove that Christianity gave them their one element of formal consistency, it would be useful to know what they actually thought. And it's surprisingly difficult to know what John Lilburn thought about religion between, let's say, 1639 and 1653. In the 1630s, he was a separatist who believed that the Church of England came from Antichrist, and it was the duty of a Christian to fly from it, and that the authority of the bishops came from Antichrist, and that they were corrupting the civil freedoms of the English people, and it was important to separate from the church. In 1653, he converted to Quakerism, and there are very full personal accounts of his Quakerism at that point. But in between, actually, Lilburn doesn't say much about what he thinks about key theological issues or key matters of church government, except that he does not think Christ left his authority in national churches. And so the Presbyterian national church is no less oppressive than the Church of England. But beyond that he doesn't believe in national churches, it's actually rather difficult to define Lilburn's Christianity very closely, and therefore to prove that it's what connects him with Wallen. And it's even more striking then that Wallen thinks they're not in agreement about their Christianity. So legal agency is critical to Lilburn's political career. He brings it into the Leveller mobilisation. You can see it as important for the formation of the campaign for the agreement of the people, and you can see people who are mobilised by that campaign, who join the campaign for an agreement because they're also interested in legal agency. John Streeter and John Waugh, but also even Wallen and Overton, who are normally thought to be more anti-formalist than Lilburn. So that's my case about Lilburn, the Levellers, and legal agency. Now on to what you'll be relieved to hear is the final slide, please. Forms, sovereignty and freedom. What does all this have to do with contemporary political debate? Well, in the Foundations of Freedom, one of the versions of the agreement of the people, an appendix, and it was the version that most clearly bears the stamp of Lilburn's input. The appendix enshrined defences against self-incrimination, that proceedings would take no longer than 3 or 4 months, that there would be no abridgment of trade, that excise would be abolished along with imprisonment for debt, there'd be witnesses for and against the accused in trials, the death penalty would be limited only to cases of murder, tithes would be abolished and replaced with non-compulsory contribution, and the interest rate would be limited to 6%. It's the kind of miscellaneous list that political theorists find unsatisfying and suggests a lack of system in Lilburn's political thought. But more charitably, a large part of this list can be explained by the thought that legal forms ensure that individuals can have their claims arbitrated in a way that safeguard the rights of all the people and their freedom to live their lives. An attachment to forms does not therefore necessarily imply a lack of radical or democratic intent. In this case, the people did not act continuously to secure their rights through majority voting on legislation and deliberation, but they acted through forms that enshrined and protected their rights to life, liberty, and freedom. So the Levellers, forms and populism, how might we make that connection? When the Levellers spoke, they did not do so on behalf of the people. This is a separate paper I've written. They did not claim to speak for the people, but rather they appealed to the people as an imaginary who could arbitrate on the claims being made on their behalf. The electorate envisaged by the agreements of the people passed regular judgment on governors, withdrawing their trust when that had not been sufficiently respected. And in the wider Leveller discussion, juries prevented the corruption of courts, and the task of reform was to put Englishmen back in possession of their rights by rolling back the prerogative. Englishmen, they said, were not slaves because they had formal legal rights. The people did not act, therefore, but they arbitrated on public claims and on the uses being made of collective institutions. The Levellers were asserting the value of accountable public institutions in defending against tyranny, and that was the basis for the assertion of legal agency. We might think of populism, by contrast, as an anti-formalist phenomenon. The people act directly against institutions, and they do so because they believe them to be hopelessly corrupted or sinister in intent. But it's quite possible to draw on the heritage of thinking about popular sovereignty that is formalist, seeing in legal norms and collective institutions the bulwarks of freedom against any, including from the tyranny of representative institutions. So this has contemporary resonances, I think. The Levellers might arm us to argue that freedom comes through legal agency, through a political identity defined in relation to collective institutions, and that can subsist with a radical desire to refigure those institutions so as to genuinely serve the public good. It depends, however, on a profound commitment to those institutions of public life, a formalism that is normally considered conservative. In such a view, in this anti-formalist view, the people can be arbiters on the process of public renewal, but not direct actors. And that is particularly important where the people are an imaginary rather than an actual political actor. So an emphasis on quotidian empowerment throws into sharp perspective what we might think of as the false promise of representative democracy, that by casting a vote in national elections, people achieve political and legal agency. There's a deep-rooted scepticism of this claim in the English quip that if voting changed the system, it would be illegal, and much earlier forms of anti-politics. Disaffection with that false promise might be answered through unspectacular, pragmatic attempts to revitalise awareness of and access to defences of life, property, and expressive recognition. This in turn might draw the teeth of anti-formalist populism, which some commentators now feel ultimately threatens, like other revolutions, to devour its own children. Thanks.
Thanks, Professor, for such an amazing talk. It was a very interesting way to have this final discussion of the semester. So I guess it was a great opportunity. I'm opening the floor now for questions. So if anyone has a question, you can make it either by posting in the chat or by using the raise hand function. We have one hand here, but I don't know the name. It's not written, so please.
That's me, Nora Carlin.
Oh, hi, Nora.
Hi, Nora.
I didn't know you couldn't see my name. You should have been able to. That was very, very interesting and relates to a lot of the ways I've been thinking about Leveller thought over the past few decades. I would like to ask a specific question about the concept of equity. Mm-hmm. Because in an early article, Colin Davis dismissed the concept of equity as somewhat callow. And that made me laugh because knowing the history, a little bit of the history of English law, the development of the concept of equity is very, very important. You, I think, very correctly pointed out that what Davis rested his interpretation on this concept of fairness rather than equity. Would you agree that equity is an important legal concept in the discourse that you're discussing?
Yes, absolutely. It's that passage, I think there's discussion about it exactly in the 150th page, isn't there, in the beginning of England's Birthright. And I did my PhD actually from the records of the equity side of the Exchequer, so I was very familiar with the equity law and its relationship to common law, and that it's a rather technical term, not at all the same as fairness. So I was making exactly that point, really, that equity means in legal discourse something much more specific than Colin kind of assimilates it to the golden mean and practical Christianity, and I'm sure it does have that resonance. But I feel, you know this as well as me, Nora, that you begin to, once you're familiar with these texts, you begin to feel that you can feel them. But I feel that Lilburn was referring to equity in that stricter sense, that a judge could set aside precedent where legal right would be served by doing that, and that is different, I think, from simple fairness. Yeah, absolutely.
Oh, thank you. Yes,
Yeah,
that confirms what I was thinking. But I very much appreciate all the additional things that you've added to that train of thought.
Thanks.
Any other questions? Lívia, yes?
Thank you very much for your paper, Professor. I'm really, for what we've discussed before, how interested I am in your perspective and how you conjugate the capacity of these subjects to act politically, even whilst operating within a religious framework of thought and all that. So yeah, it was fantastic. Thank you. I was wondering, you mentioned on one of your last slides about how you perceive that what brings the levelers together, even though Lilburn, Overton, and Walwyn all have their differences, is their perception of legal freedoms and not necessarily religion. And I thought that was really interesting because, in a way, I think that even though Winstanley and the Diggers are a lot more guided by mysticism and religion, I think that's something that's also possible to identify within them. So I was just thinking if you could expand a little bit more on that topic about how do we make this division of what brings them together as a group. Thank you.
Yeah, I think so. One way of distinguishing, for example, the Levellers from the Diggers is that the Levellers were proposing a constitutional settlement to establish a peace, and the Diggers were establishing a new utopian society. And so it wouldn't necessarily even be that they had to have different views. They had a different practical task in hand in those two contexts. So I don't know Winstanley nearly as well, of course, but much of his formation was common with Lilburn, and much of his subsequent life was much less dramatic than his digging experiment years. But the digging experiment years allowed him to express that Christian aspiration and utopianism. Well, suppose Lilburn had that same Christian utopianism, the agreement of the people is not the place to express that. And in a way, I think that's what Colin Davis might be saying, that the agreement of the people is just this thing that they're doing, but what they actually care about is Christian utopianism. But still, I think it's situational. The distinction between the Levellers and the Diggers may not be necessarily ideological. It can be what they're trying to do, the context in which they're actually acting. And certainly, if you're, as Winstanley was, you're establishing a new society, then it's much easier to be anti-formalist, I suppose. But even accounting for all that, when I read Winstanley, I think I read someone quite different from Lilburn. Winstanley's religious experience is so intense and immediate and so urgent for him, and such an urgent course of action. Whereas for Lilburn, his religious experience is intense and immediate, but it's a source of strength rather than a direction in his life. I think it allows him to suffer the blows he experiences and gives him the courage to take on the authorities and so on. So it's a complicated question, and they obviously share a lot. But I do, in the end, my feeling about Lilburn's religious experience in those years is that it's quite different from Winstanley's religious experience in those years. The Lilburn experience after 1653 is much closer, when he embraces the world, looks for his own spiritual renewal. Then he seems to be responding directly to God's promptings as a source of action. But I think in the 1640s, it's hard to see him doing that. He's responding against immediate tyrannies and immediate obstructions and infringements and injustices, and drawing strength from his Christianity in doing that. Complicated question, but that's how I'd begin to answer it. So I'm not at all saying Lilburn. I mean, forgive me for being a bit weary about this. I'm not saying Christian Lilburn was not Christian.
No, yeah, absolutely. I understand that. Thank you. That was perfect.
Next, we have Jonathan Scott, please.
You're muted, Jonathan?
Yeah, you're muted, Professor, sorry. Now it's still not working.
Jonathan, you're muted.
Excuse me.
Yes, now it's working.
Mike, you have woken me up at 4:30 in the morning, but you haven't got me out of bed, as you can see. That was a fantastic, rich paper, which has plunged us back into so many important questions about the levelers. It's hard for me to come up with a single question, but I think what I want to say is that you've absolutely succeeded in making the case that Lilburn and his way of thinking and speaking and acting is as central to English radicalism in the 1640s as anybody else's experience and way of speaking. You haven't, though, convinced me of anything in general about the levelers, except that we have to revisit the key question about the levelers, which is whether it makes sense to speak about them collectively at all. And you've reminded me that if we are going to speak about them collectively, it's useful to do so by thinking about them as a mobilization, which means that they're a sort of process in time in a chronological as well as spatial location, which means that they are a protean thing that's constantly evolving and changing and moving at speed, also with people being discarded and added and so on. So they're tremendously difficult phenomenon historically to pin down, but I mean, immensely rich and interesting. And for what it's worth, my view is that I think it's really difficult to make any, I think you are reminding us it's really difficult to make any general statements about their locus of ideological cohesion, if they had one. I'm not sure how promising it is to say that they're as much about legal as about religious thought of a certain kind. You've left out social and political thought, at least as foci of your argument, but you could add those two polarities as well. They're working in a spectrum that covers all of those four things and other things too. And you'd have to think about that whole spectrum to think about whether there is ideological cohesion. Other ways of thinking about their cohesion that you've kind of touched on in the paper include the agreements of the people. And again, I think because the agreements of the people are particular documents that fly up at certain moments in this protean process or mobilization, it's not at all clear to me that historians have established that those are documents or proposals around which a movement coheres, and that they're more important in that respect than any other of the many interesting documents that the levelers produced in their history. And the final example is Warwin saying to Lilburn on your slide, although we disagree about religion, I will always honor you for your commitment to the common freedom of the people. It doesn't follow from that Warwin is saying it's not religion that unites us, it's our commitment to the common freedom of the people. What that actually says is that Warwin is, although pissed off with Lilburn, probably about Lilburn's wrong thinking about what Warwin really most cares about, which is religion, is finding a nice thing to say about him and expressing genuine admiration for the things that he can honestly praise and admire. And that's much less than historical evidence of a key, thread of cohesion. So I think you understand what I'm saying. I think what you need to do now, Mike, is write a book on the levelers as a mobilization and probe these questions of whether it's sensible for historians to persist with this term, and what can be made of it generally.
Yeah, I think, I mean, I agree with a lot of what you say there, and I think I owe some of it to you too. I think it was reading about the level as a moment, not a movement, that prompted me to, which I think, you said something like that somewhere. So I do agree with a lot of that. I think, just to explain myself a bit, I was trying to say that the real quarry for me is not leveller thought, it's the history of mobilisation and the history of popular politics. And in another paper, I end up arguing that Lilburn is a new kind of politician who doesn't have public office, doesn't have an estate or an established profession. He commands the public stage through his manipulation of the arts of communication and by mobilising popular sentiment and popular support. And you can see that in Wilkes and people on from here. It's hard to see people in the past who do that except with a peasant army at their back. So my real interest in the Levellers is sociological. It's about the form of political mobilisation that the Levellers suggest. And from that point of view, I'm not really trying to recover what the core ideological, the core ideology is, because I think on any modern mobilisation of such a thing, there's a programme, some kind of zero carbon target. The people come to that to support that mobilisation for a variety of ideological motives. So sociologically, what's interesting, I think, is the way that the mobilisation happens rather than the ideology that's thought to underpin it. So I think I'm being quite deconstructing of the Levellers ideologically, and quite sceptical that there is a Leveller ideology or Leveller Christianity, but quite clear that there is a mobilisation. And what's most challenging from what you've just said is that I might be too interested in the agreements of the people, because obviously in that view, it's the agreements of the people that hold everything together. So, that's why I've written it the way I've written it. So I don't want to say they're held together by law, absolutely not. But I did want to say that this legal agency is an important strand for these thinkers and for others in the 1640s, and because of the nature of this paper, that's something that can contribute to our thinking about the current limits of popular will and populism. But my actual interest in the Levellers was more about this new style of politics and the art of using print and public performance of suffering and secularization of martyrdom and so forth to mobilize sentiment behind a concrete program. So, but I agree. It's opening up a lot of issues, which perhaps we should have. We are due for another thrashing around.
I like that answer very much. Thank you.
Next, I will give the floor to Julian, please.
Yes, hi. Thanks very much, Mike. Fascinating paper. Very much a non-specialist's question, but it's a sort of methodological question of, I'm listening as much to the debaters to your paper as to one of the ways in which you might sort of tackle questions like, are the Levellers essentially about this or that, is what do their enemies say about them? What do their critics say about them? And, how do other people position themselves around them? And, what you've given is a sort of, an internal picture of what they themselves say, which obviously is where you have to start and is an essential thing. But particularly if you're looking at a mobilization, you need to look at the other people around. So I'm sure you could say a lot about that, but can the way in which their enemies react to them tell us anything about what they're about?
That's another annoyingly good question, to which I don't have good answers. I mean, the term, to start with the term leveller, that's a claim that they're socially levelling, and they continually had to defend themselves against that, because the strand of Christian egalitarianism made it sound like they thought everyone was the same. and Lilburn and the legal agency types were all saying that prerogative and status don't matter, and we should all have equal rights to the law, which again sounded quite like the levelling of men's estates. And then when that was tied up retrospectively with the franchise debate about who gets to remove the executive, they were written about as Britain's first socialists, and that line of interpretation of them as socially levelling was got legs in the modern historiography too. So they were quite, and Lilburn, who's the person I really know about, was always very anxious to distance himself from any claim of social levelling, and genuinely wasn't interested in social levelling, was mainly interested in becoming a gentleman. So I got another annoyingly interesting question just popped up on my screen. I'll try and talk so long that I don't have to answer that one. So there's that this Christian egalitarianism and legal equality amounts to a kind of social anarchy, and they collectively say it's ironic that we who've spent our whole careers arguing for a good government should be accused of wanting no government. So I think that's a key element, and it makes it, their presentation then is skewed by having to answer that charge. And again, what they say in answer to that charge muddies the waters about how they would actually present themselves if they were, given a free and open page on which to present themselves. And yes, I think that's what I'd say, is that it seems to be so corrosive, even the agreements of the people, even though the agreements are formalist by comparison with the diggers, the agreements of the people look like they're corrosive of social decencies and will lead to an anarchy, which of course is a very common accusation of any democratic idea in early modern Europe. And then Lívia is the person to answer about this, but that distinction at the top of my presentation between levellers and true levellers, there was then an argument that the diggers embraced the phrase true levellers because they really were levellers. But Lívia, perhaps she'll give us a paper on it at a future date. It's more complicated than that. There's a question in the chat. Christopher, could I ask you to elaborate on that a little bit, about which continental reports you're interested in?
So, can you hear me?
Yeah.
Quite a long time ago, several years ago, I did some searches for radical Protestants on the continent, particularly in what's now the Czech Republic, and I came across a significant cache of documents in Czech, I might add. Of course, I can't read, but describing the levellers, their views, organisations, and numbers, which actually was surprisingly small from what little I know about them. So I just wondered if you've got any views on them. I'm not aware of anybody ever having written about them.
No, I'm not. I don't know. I'm woefully ignorant about that. Actually, I know a little bit about the hostility Lilburn encountered in exile and suspicion from conservative forces in Europe, but I don't know much about fellow travellers that he encountered or connected with. The Czech connection is quite interesting through one chap I do know about is Culpeper. Cheney Culpeper, whose letters contain lots of resonances of what we think of as leveller language. And there's a strong connection through Hartlib to Bohemian radicals and to the radical Protestant tradition in continental Europe. So I'm sure there's something to be unearthed there, but I'm afraid, Christopher, I haven't got anything sensible to say about that, really.
Do you have any further questions? Yeah, please, Jonathan.
Can I just another thought about what their enemies say about them? I'm sure you are more aware of this than anybody, Mike, but of course, one of the reasons that Lilburn talks so much about the law is that he's spending so much time in prison or otherwise persecuted by legal instruments brought against him by his enemies. And that's also absolutely true of Streeter, who among 1650 Republicans is distinguished really by the amount of time he spends in prison and by his what looks like quite willful courting of imprisonment and legal persecution. It's another, in relation to Lilburn, it's a reminder of how much of his thought and speech is, as it were, a product of his biography. But beyond that, how much of his thought and speech and biography is a product of the actions of his opponents rather than of his own. So to that extent, Lilburn's thought and biography and speech is a product of the situation and his struggle with his opponents in that situation rather than anything kind of intrinsic or intellectual about him personally.
Yeah, again, I think that's very shrewd. I think I stress the family history because I wanted to locate it not simply as reactive, but drawing on that experience of gentry honour and legal right and vindication and so forth. And the other key thing, I think, is the publication of Cook's volume on Magna Carta, which was 1643, I believe, and Lilburn definitely studied in prison in 1647 with Judge Jenkins. So I think he was prompted to think through his experience prompted him to look at the law, but then having looked at the law, he thought through rights through a legal frame. I think it's more than just that he was fighting the immediate battle. So I think he did intellectualize his situation, and I think that's much more important in his reading as far as we can tell. I mean, his main reading is the Bible, I have to say, slightly against my own interest to say it, but his main interest is the Bible. But in the early 1650s, he read Machiavelli pretty clearly for the first time. So I think to the extent that he's thinking about secular rights in an abstract way, it's through Cook and the common law, based on the inheritance of a 17th century gentleman. But it's absolutely right. His public appeal depends on his biography too. A key claim is what's happening to me now could happen to you tomorrow. I stand for your rights. So the dramatization of his own sufferings is central to his political success. So it's biographical in more than one sense, I think. Yeah.
Any other questions? I guess Lívia was raising her hand, but I don't know if it was a mistake or if she wants to add something.
No, it's just that I was thinking that it was more of a comment than a question. I think it's quite cringy when people always say that, oh, I have rather a comment than a question. But it was just addressing what Julian mentioned about how they were perceived and what this tells us. And Professor Braddick was talking about what brings the levelers together as a group. Should we interpret them as a group? Should we interpret them as a mobilization? And I was just thinking about how when Lilburn does these exercises, how you mentioned of strongly dissociating himself from this criticism of and accusations of social leveling and all that, it's still also quite intriguing how, even though they despise the label levelers, it appears somehow sometimes in their pamphlets, and the fact itself that they address this criticism by these other parts that address them as levelers is just somehow a clue of a recognition of them as a group, maybe of recognizing that means them. And even on the episode of the diggers appearing in the scene and the case for levelers and true levelers, the fact that Lilburn doesn't point out and say, yes, those people on that hill, those crazy diggers, they are actual levelers, we are not. So focus on them. He does not do that. He tries to dissociate even the pejorative, even the accusation, that he doesn't want to his name calling to be associated with those crazy diggers. So I think that also maybe adds to us perceiving them. I don't know, how do you think that would add to perceiving them either as a group or a mobilization? I don't know, I was just thinking how that could fall in that analysis.
So sorry, that they that he doesn't embrace. Sorry, I missed the.
No, sorry, it's just that he does not embrace, he does not endorse levelers.
Yeah.
But when the diggers appear, and various newspapers and newsbooks, attribute them to being levelers, and the True Levelers pamphlet comes up and all that, that seemed to be a chance for Lilburn, for example, to accuse and say, that is levelism.
Yeah.
That is not what I'm proposing. And he does not do that. He tries to dissociate himself even from the name calling, always saying, almost recognizing that this is our bad label, to not mobilize this bad label to these other people who are even, I was just thinking about that.
Yeah, I think that's right. They and it's true. I think all the examples I can think where they distance themselves from the term leveler, it's defensive, where it's the four of them, or whether it's Lilburn in Amsterdam, where the authorities are very suspicious of him. They're very keen to say we're not levelers, but I can't think of them denouncing others. And even Lilburn's a very difficult character, I think. Admirable in lots of ways, but difficult. And but even his enemies say he's not indiscriminate in his attacks. He attacks people who attack him or threaten what he's trying to do. There's no collateral with Lilburn, and I think that would fit with that digger episode. That I'm not a leveler. You've got an argument with those people, you have an argument with those people, but I'm not a leveler. And I think there is, even his enemies would say, Lilburn had a code, to quote the Big Lebowski, at least he had a code, Yeah.
Lívia, can I ask you if Winstanley ever accepted the label true leveler? Does Winstanley identify as something called a true leveler?
So that's the $1 million question, because there's some ongoing debate whether the diggers or Winstanley at any point actually entitled themselves as true levelers. Professor Ariel Hessayon argues, for example, that the pamphlet should be read as true leveler, meaning Jesus. So and they do refer to Jesus as the true leveler in a pamphlet later on. So it could have been a choice of the printer of Giles Calvert. I'm currently investigating that, trying to assess where that came from. But no, the diggers, apart from that tile, they don't address themselves as true levelers in their pamphlets, but they are addressed by others as the true or the new levelers. Sometimes they only appear addressing themselves as diggers.
Okay, so what this suggests to me is that at least that pamphlet title is evidence that by the time the diggers appear in practice, the phenomenon labeled by its enemies leveling is sufficiently publicly prominent for people to know about it and to talk about it in public discourse. It's not clear to me that what historians now talk about as the digger movement, or the body of incredible writing by Winstanley in particular that's so interesting to us now, was very publicly prominent in 1648, 1649, prominent enough for Lilburn to try and unburden himself of an unwelcome label by reapplying it to someone else. I mean, I'm not sure how big a deal at the time publicly digging was, as opposed to a threat to the sort of parsnip and carrot yield of a particular hill at a particular time. I think, you know, it's subsequently digging has subsequently become famous because both the practice and the thought are so brilliant, really, for historians to think about. But I'm not sure if at the time there's anything like the same profile as the so-called leveler phenomenon.
If I can add something to that discussion, and maybe I don't know if I make a comment or a question to Professor Braddick, but something that really strikes me is the rhetorical effects of mentioning those words, like mentioning leveler, mentioning digger in this particular public debate. Because as we are talking about something that also occurs in the print culture, we're talking about also engaging a public sphere or anything that we would like to talk about in this sense. So I don't know is it possible to make any further comments on that particular issue of the rhetorical appeal of mentioning those issues on pamphlets and other political tracts as well?
Yeah, so I tried to, well, my book about Lilburn, I was very careful not to describe as a biography because it's a political, I described it as a political life because there are 150 or so publications or more that construct a public Lilburn and contest a public Lilburn, but there are hardly any manuscripts, and there are letters to his wife that are printed and letters to other people that are printed immediately. But I found, I think, 2 or 3 manuscript letters for Lilburn. So I was writing a book about the Lilburn function, I suppose, rather than Lilburn the person. And he constructs quite a persona very carefully as someone who is prey to oppression and then fights it on behalf of all his fellow citizens. And he likens himself to the Christian martyrs and to Christ, actually, a bit vainly. But it's important that the suffering, he never brings the suffering on himself. He never invites the suffering. He endures it through God's strength and so forth. So there's this very public construction of the innocent abroad. And then there's just a ton of publications saying, he started it, you know, he did this, he did that. If he'd just not done this, there wouldn't have been any trouble. So the whole Lilburn phenomenon is a print phenomenon, and that's where my interest in the mobilization came from, really. It's not, you don't really need to know Lilburn the person to understand Lilburn the political effect. I think that's really true of the much, and again, this is really something that Liv would be better placed to answer, but Liv is working on this for more generally for groups, the diggers and the true levelers and so forth, how they also live in this world of construction and the people acting through these public constructions and public assertions, which are continually contested. The debate between Lilburn and Prynne in Lilburn and Bastwick too in 1645, they start saying things about what kind of accent he had in 1637, and he's forced to defend himself from accusations that he plays dice and has a drink on a Sunday, you know, and so that's exactly the world that they're in, and I think it's exactly the world, as Jonathan has suggested, that these terms like leveler get deployed, and you're never in command. You're always, to some extent, responding to someone else's construction of what you've just tried to construct. And I think those group labels work in that way. Absolutely. I mean, a one that would be interesting to study would be Presbyterian. Actually, the way that goes so far beyond argument about Presbyterian and about theology or church government. You know, what Presbyterians comes to signify is really, you know, quite contested and quite extensively discussed. You know? So I think print culture, absolutely, and you couldn't. I don't think you could have had the levelers, and you couldn't have had John Lilburn without print. I think that it's a distinct form of politics. It's possible because of print.
Thank you, Professor. If we don't have any questions, I think we should stop now because of the time. But I will like to invite everyone to keep tuned on our social media and emails, because we will have a break now during August, but we will come back in September with other fabulous talks, and everyone is invited to attend them. Meanwhile, if you want to catch up all the other lectures that we have, we're going to post the videos online or in our YouTube channel in August, probably during this break. So please keep tuned to all the news that we were going to post. And I would like to thank Professor Braddick once again for accepting our invitation and for giving such a fabulous lecture, and for everyone for attending today. It was really great to have this whole semester of discussions. We are very thankful to all of you. So thank you, and see you all in September.
So I should have thanked you at the start for inviting me, but I'd like to thank you on behalf of everyone for setting this up. It's been a fantastic programme, and I'm really pleased that it's running on into the autumn as well. So well done, Verônica and Lívia, on behalf of my fellow attenders.
Thank you all.
Thank you. Thank you.